Justice of the Philippines and the Associate Justices of the Supreme Court of the Philippines are now entering the virtual session hall. Hear ye, hear ye, hear ye, all persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Attorney Maripe, call the petitions.
Your Honors, good afternoon. This is a continuation of the oral arguments on the 37 consolidated petitions assailing the constitutionality of Republic Act No. 11479 or the Anti-Terrorism Act of 2020.
Appearances.
May we call on the counsels for the petitioners?
Your Honors, good afternoon. This is Edsel Lagman, same appearance in GR number 2525.
Anong GR natin sa ano? May kopya ka ba dyan? Kalimutan ko yung GR number natin.
Continuing appearances, please.
Good afternoon, Your Honor. Attorney Darwin Angeles. Same appearance for petitioners Justices Antonio T. Carpio, Conchita Carpio Morales, and UP Law professors in GR number 252736. We are ready, Your Honor.
May it please the Court, good afternoon, Your Honors. The same appearance, the Free Legal Assistance Group through Attorney Theodore Te appearing for petitioners in GR number 252741, Your Honor. Ready, Your Honor.
Good afternoon, Your Honors. Attorney Evelyn Ursua, respectfully appearing for the petitioners in GR number 252747.
Good afternoon, Your Honors. Assalamualaikum. Attorney Bantuas Lokman, together with me, Attorney Musa Malayang, respectfully appearing as counsel in GR number 252759. Thank you.
Good afternoon, Your Honor. Ephraim B. Cortez of the National Union of People's Lawyers appearing in GR number 252733.
Good afternoon, Your Honor. The Honors, Attorney Randall Tabayo, appearing as counsel for the petitioners, Integrated Bar of the Philippines and its Board of Governors in GR number 253124.
Sino ba?
West. May we call on them?
May we call the respondents' counsel?
Good afternoon, Your Honors. For the respondents, Assistant Solicitor General Marisa de la Cruz Galandines, ASG Rex Bernardo Pascual, ASG Raymond Rigodon, ASG Diane Castañeda de Vera, Solicitor Ricardo Poquis, Associate Solicitor Dominic Clavano, and this representation, Your Honor, ASG Bernard Hernandez. Ready, Your Honor.
The court recognizes the presence of the Amici Curie, former Chief Justice Renato Puno, and former Associate Justice Francis Adelessa.
Your Honor, please. Incidentally, Your Honor, the Solicitor General who has to step out of the office in order to attend an emergency meeting, but has committed to join the OSG team as soon as he can, extends his warmest birthday greetings to retired Chief Justice Renato Puno. Happy birthday, sir.
Okay. For purposes of this afternoon's proceeding, the court would like to make an announcement or a few announcements based on the special session we had earlier. So with respect to the manifestation with motion dated May 12, 2021, filed by petitioners counsel in GR 252768, the court would require respondent to comment. As regards the omnibus motion to expunge the testimony, video presentations, and annotations of Respondent National Security Advisor Hermogenes C. Esperon and Cancel Esperon's recall to continue his testimony, the court resolved to require respondent to comment. The court also decided not to continue the interpellation of Secretary Esperon based on the compliance that they have submitted earlier. Moreover, there are specific questions that the members of the court would like to address, would like the respondent, Secretary Esperon, to respond. And the court will issue a resolution to that effect, incorporating the specific questions addressed to Secretary Esperon, which will be incorporated in the respondent's memorandum. The court also agreed that for purposes of filing memorandum, the court will receive only 6 memorandum based on the clusterings made by the petitioner's counsel, insofar as the issues that they have opted to be discussed by their respected selected counsel. So technically, the court will only receive 6 memorandum or memoranda. The court also resolved that a show cause order be issued to Attorney Te for his statement post-hearing last time, which was posted in the social media. Thereafter, the court will hear the amici. So may we call on the amici, his Honorable former Chief Justice Renato Puno, for his statement. Happy birthday, Mr. Chief Justice from the Court and Bank.
Thank you, Chief Justice. May it please the Honorable Court. We are all students of the history of threats to peace and security. We know how these threats have evolved. The changes in the nature of the threats, the metamorphosis of the acts constituting the threats, the mutation of actors driving the change, and so forth. We saw all these changes in the different tools and techniques used by man to fight despots, to resist tyrannicides that led to World War I and World War II. And we observed their refinements during the Cold War. Terrorism is the latest variant of these threats to peace and security. The world saw how deadly and destructive terrorism is in the September 11, 2001 attack of the United States and in the siege of Marawi. The longitude of injury spawned by terrorism has mothered the call for states to stage a war on terrorism. The dilemma is that we are called to fight a war that is not defined as a war in international law. In a traditional war under international law, the rights and obligations of the warring states, the combatants and the non-combatants are defined with precision. But terrorism is not a conventional war, yet we label it as a war fight it like a war, and that bridge turmoil to the protection of human rights. Given their desire to understand and contain terrorism, states have isolated the distinctive characteristics of terrorism. Namely, number one, it is difficult to deter and detect because it is done in the most clandestine manner and is executed swiftly. Number two, the magnitude of the death and destruction it can cause is unimaginable, given that the perpetrators may have access and can use biological and chemical weapons and other weapons of mass destruction, including nuclear weapons. And number three, the difficulty of catching the perpetrators, considering the porous boundaries of states and the globalization of the world into a village. And so, prescinding from these expert studies, the United Nations itself, through the General Assembly and the Security Council, have called on its member states to criminalize terrorism in their domestic laws, impose new sanctions ranging from the penal, the political, economic, and financial. The internationalization of the fight against terrorism will breed novel legal problems, as it will require, among others, an in-depth study of the rights and obligations of member states of the United Nations under its charter, and an examination of the applicability of certain norms of public international law and humanitarian law in domestic disputes. It is difficult to capture the different dimensions of these problems, as more probably than not, issues that are sui generis in nature have to be resolved. A hint to these difficulties is the continuing failure of the United Nations Security Council to craft a definition of terrorism that each member states can accept without any asterisk of reservations. As a consequence, different models on how to combat terrorism in compliance with the call of the United Nations Security Council have been developed. The United States has created its own model. The European Union formed its own. The Commonwealth countries modified their own, and so did various Asian countries. This lack of consensus on the definition of terrorism will continue to be a pestering problem, considering the irreconcilable philosophy on human rights of each member states and the different designs of their constitution. Further, Your Honors, anti-terror law models will demand a hard look on the new disruptions its enforcement will inflict on individual rights protected in different state constitutions. In the petitions at bar, petitioners allege that just about all the rights in our Bill of Rights will be illicitly compromised by the Anti-Terror Act, from due process, freedom of speech and expression, freedom of association, freedom of religion, freedom against unreasonable search and seizure, the right to privacy, the right against ex post facto law and bills of attainder, the right against cruel, degrading, or inhuman punishment, academic freedom, and so forth. Petitioners also allege that the Anti-Terror Act wrecks the principle of separation of powers and checks and balances, which is the touchstone of the rule of law. Upon the other hand, the government contends that the new restrictions on liberty imposed by the Anti-Terror Act are benign, demanded by national security, and indispensable to ensure the continuing exercise of individual rights. These are the cases that pose the greatest challenge to judicial wisdom. For in collision course is not a right versus a wrong. At odds are not the forces of good versus the axis of evil, but on loggerheads is the push of a right versus the pull of another right. The right of individual is to be protected, and the right of national security to be upheld. Both values recognized by the design of our Constitution. The dangers that lie ahead all of us who covet a Solomonic solution to these contending values of liberty and security are well expressed by Fernando Reinares, a Spanish terrorism expert. For him, the competing interests of safeguarding rights and increasing the effectiveness of law enforcement in fighting terrorism is, and I quote him, generate important tensions that impact the overall government policy regarding anti-terrorism. Therefore, he said, the governmental response may oscillate between excesses and defects. On the other hand, he said, there is a tendency to trivialize terrorism, reducing it to just another criminal offense, and thus neglecting or minimizing the links of the crime to political conflicts, and therefore avoiding specific ways of dealing with the issue that depart from the standard responses to crime. On the other hand, he continued, there are approaches that tend to exaggerate the dimensions of terroristic acts and thus justify a disproportionate use of state force to control such violence. Your Honors, we are to seek the right balance between individual liberty and national security. This is not a case of all or nothing matter, but a matter of more or less. The resolution of the 37 petitions at bar will certainly lead to the adjustment of the existing balance between the rights of an individual against the right of the state to safeguard the security of our people. The Anti-Terror Act has changed the legal approach of the government to check the particular crime of terrorism. Heretofore, our laws towards crime is essentially punitive, prosecute violations of our criminal laws and penalize the violators. The Anti-Terror Act's approach is more radical when the crime involved is terrorism. The government is allowed to take preventive measures to stop the violation from happening. And for this purpose, the government is given new tools such as detention and surveillance of suspects. To complicate the problem, the United Nations Security Council has passed binding resolutions on member states on how to preventively contain terrorism, imposing sanctions that carry legal, political, economic, and diplomatic dimensions. The Security Council, in other words, encourages preemptive action and not just reactive actions. This approach is sometimes called aggressive self-defense. How to strike the balance between individual rights and national security in light of the threats of terrorism will not be a walk in the park. The new balance should take into account the architecture of our democratic government laid down in our Constitution, its pillars of separation of powers, checks and balances, inviolability of fundamental rights, the rule of law, the right of the minority against the tyrannicide of the majority, and other propositions and virtues all embedded in our Constitution. The new balance should also consider the interplay between our Constitution and public international law, including the developing international humanitarian law. At the moment, the point of the balance may remain an incertitude. In due time, however, I have no doubt that given its collective wisdom, the court can capture all the fugitive ideas necessary to fix the point of the needle that will correctly balance the needs of individual rights and the necessities of national security. The balance, Your Honors, should not reduce individual rights into insignificance, for they are inherent to human dignity. Neither should the balance put an end to the security of the people, for the people did not enter into a suicide pact when they ratified the Constitution. The ideal, Your Honors, is for us, for the people, to be both free and safe. Your Honors, I have submitted a short position paper where I have discussed my views on the standing of the petitioners on the merits and demerits of their challenge to the constitutionality of the anti-terror law on grounds of bigness and overbreadth. I have also expressed my constitutional concerns on different provisions of the anti-terror law, on the provision on designations, proscription, arrest without judicial warrants, on surveillance, on the right to travel and other areas. If it will please the Honorable Court, I'm ready for interpellation, or upon their instruction, I can just expand the position paper that I have submitted to address the many concerns of the court, which came out during the various hearings on the constitutionality of the anti-terror law. Thank you, Your Honor, for the privilege of addressing the court as amicus curiae.
Thank you, former Chief Justice Puno. The court would appreciate receiving your expanded discussion, as in addition to what you have stated in the position paper you have earlier submitted to the court. We call now former Associate Justice Francis Adelessa, also as an amicus of the court. Thank you, Justice Adelessa.
Chief Justice Alexander G. Hesmundo, Honorable Justices of the Court, good afternoon. Thank you for appointing me amicus curiae. Good afternoon to Mr. Chief Justice Reynaldo Puno, and happy birthday, sir. It is my honor to share amicus curiae duties with you, former Chief Justice, and one whom I deeply respect. May it please the court. When I was younger, Attorney Jose C. Concepcion, the head of our litigation group, counseled me. And I quote, he said, "If by the grace of the Almighty, you ever get to argue before the Supreme Court, do not ever lecture them on the law. Stick to the facts." End of quote. As amicus, I humbly present the following views based on my estimation of the allowable facts and the applicable law as already known to you. First, Republic Act number 11-49479, otherwise known as the Anti-Terrorism Act of 2020, or the ATA, was signed into law by President Duterte on July 3, 2020. Within a matter of days, the court was deluged with petitions from more than 400 institutional and individual petitioners to challenge the law's constitutionality. At this juncture, Your Honors, permit me to have a short detour on the history of the many challenges to the ATA, all in the name of the principle of direct injury plaintiffs, a principle which we shall highlight shortly. On February 4, 2021, Japper T. Gurung and Junior U. Ramos were criminally charged with violation of the ATA before the Regional Trial Court of Olongapo City. Their petition for intervention in this case was, however, subsequently dismissed by this court on February 21, 2021. Now, at the oral arguments held last April 27, 2021, the Solicitor General called attention to 3 cases involving 3 individuals in Negros Occidental. These cases were allegedly stated by 23 petitioners in these cases before us. In their joint motion of November 26, 2020, and by some petitioners, notably Petitioner Bayan, in their compliance and manifestation dated November 18, 2020. Then, Solicitor General Palida manifested to the court the existence of three more cases, not, I repeat, not on record. All of them apparently filed under the ATA. First, four criminal cases were filed in Holosulu over the August 24, 2020 bombings, with indictments against 13 individuals and several John Does and Peter Does for violations of sections 4A and 4D of the ATA. Number 2, another case for violation of section 4D of the ATA was filed and is, quote, pending, close quote, before the RTC of Gubat, Sorsogon. And third, most significant of all, recently, the ATC, applying section 25 of the ATA, designated the Communist Party of the Philippines, the New People's Army, as, quote, terrorist organizations, close quote. Your Honors, my point is this. As for the matters of record, save for the petitions of Guring and Ramos, and possibly of the 3 others in the Negros Occidental case, none of the petitioners in these cases has claimed direct, personal, or constitutional injury, or has alleged actual prosecution under the ATA as to be entitled to relief. While a case for pre-enforcement review of a criminal statute is possible, the same is allowed solely on the grounds of vagueness. None, I repeat, none of the petitioners has sought to avail of this exception. I humbly submit that following this court's ruling in Southern Hemisphere Network versus the Anti-Terrorism Council, all 37 petitions should be dismissed. This is, of course, without prejudice to the continuation of all the other cases cited by the Solicitor General. In fact, if the Solicitor General is correct, there are 3 other cases not before this court where there are other direct injury plaintiffs. I therefore agree with the court's denial of the petition of Messrs. Guring and Ramos. Your Honors, the Supreme Court is not a trier of facts. Cases presenting factual issues, such as the veracity of the allegations of torture of petitioners Gurung and Ramos, must first be tried under the doctrine of hierarchy of courts and following the rules of evidence before first the trial courts and then on appeal by the Court of Appeals. Petitioners cannot short-circuit this process by simply invoking the transcendental or paramount importance of their cases. This is the court's clear ruling in Gio Samar versus Department of Trade and Communications. Second, and for the complete avoidance of doubt, the issues raised by petitioners against the ATA are, repeat, are very important. The ATA implicates civil liberties dear to all of us. There is, however, an absolute dearth of facts in the present case record as of the moment to support a ruling against the ATA at this time. The ATA is an act of Congress that supports the presumption of constitutionality. I stress the words presumptively. For when and if constitutional lines are crossed as borne out by the facts, we know, I know, where the court's heart lies. Let me expound, Your Honors. To simplify, let me go straight to the example raised by Justice Amy Lazaro Javier, how a fictional Captain Ree should react to a threat from an IT genius to bomb 5 hospitals for children. With the court's kind permission, I would like to pose a somewhat similar question to petitioners. How should our soldiers act upon receiving a reliable but sketchy tip regarding a possible location of an incredibly elusive high-value target? Let us say this target, one they have been trying to catch for 2 decades, but, quote, who've always managed to evade the net, doesn't stay long in one location, moving about to avoid getting hunted down, end of quote. The information our soldiers receive, while the most certain they've received about the target in a while, is admittedly awfully vague. And the time to carry out any action to catch him using such information is severely limited. Would councils propose that our soldiers wait to receive more complete information, but risk letting this valuable target escape to terrorize another day, or act as best as they could and try to catch him based on the vital, although be it limited, information they already have. Now, Your Honors, unlike the fictional Captain Ree, Your Honors, our brave soldiers have, in fact, in at least one occasion, actually been confronted with the very scenario I have just shared with you. On May 22, 2017, our men in uniform decided to act on intelligence they received and tried to capture Isnilon Hapilon, one of the most notorious terrorists known to us. As an account of what we now know as the Battle of Marawi reports, the military operation on Hapilon ultimately, quote, preempted a plan to turn the Islamic city into an ISIS-controlled province, end of quote. I note, of course, that petitioners here represented by many of the councils, so many of the councils whom are my friends, have offered responses. For instance, at one hearing, one council argued that, and I quote, "What is really lacking is good police work and good intelligence work," end of quote. Well, Your Honors, maybe. But the fact is, the Hapilon raid left 3 soldiers dead and eight other soldiers wounded. It also took 7 armors until 5:30 in the morning of May 25, 2017, to extricate the raiding team. By the end of the Battle of Marawi, there was a total of 2,000 dead. In contrast, 2,977 people, 2,977 people, 20, I repeat, 20 of them Filipinos, died in the 9/11 terror attacks. Was the failure to predict or to interdict the 9/11 attacks a case of lack of good police work or lack of good intelligence work? It may be that people other than judges should issue warrants, or that detention of terrorists for up to 24 days without filing any charges is unreasonable, or that maybe sometimes our operatives with intelligence information. It may be the intelligence are just too inept. Or maybe they are just
Justice Adelessa.
attacking inadequate measures, or can the court decide against the 80 at this. The U.S. Supreme Court struck down a provision in the Immigration and Nationality Act for being unconstitutionally vague. I believe that the Chief Justice wanted to emphasize that the U.S. Supreme Court decision in the Maya was based on a case record built after hearings before, number one, an immigration judge, number two, the Board of Immigration Appeals, and number three, the Court of Appeals for the Ninth Circuit on appeal. My point, judges of the RTC and justices of the Court of Appeals are not only equipped to receive and ascertain the facts for this court, they also, in their own right, make constitutional law. I think it is time we start hearing them first by giving them the first crack at cases such as this. Relatedly, Your Honors, counsels for petitioners belittle the attempts of the Department of Justice, headed by Secretary of Justice Bernardo Guevara, to fill in the details of the ATA through the issuance of implementing rules and regulations, or the IRR. Your Honors, the ETA's IRR are, however, a far cry from the usual IRR, which but copy the law and no more. If the DOJ has arrived at narrowing definitions as held in Holder as to save the law from being declared unconstitutional, then I ask, what is so wrong in allowing the DOJ to do its share in defining constitutional law? At the May 11 hearing, Justice Rodil Salameda asked the very legitimate questions about the alleged vagueness of the terms used by the ATA to qualify the definition of terrorism under Section 4, to wit, quote, to provoke the government, close quote. To which Justice Benjamin Kagiwa sagely added the alleged vagueness of the terms, quote, to create an atmosphere of fear and, quote, to seriously destabilize or destroy political structures of the country, close quote. Through Your Honors, these terms are not defined in the ATA nor in the IRR. More important, however, the Southern Hemisphere has taught us, citing the case of Holder versus Humanitarian Law Project, that there is a procedure by which the question of constitutional vagueness can be brought to the Supreme Court in a question of criminal prosecution. This is by means of a so-called pre-enforcement review. This is, of course, in addition to the classical modes known to us of raising the question of constitutional vagueness. That is, by certiorari at the time of arraignment or on appeal from conviction. Your Honors, unfortunately, none of the petitioners have sought a pre-enforcement proceeding. Finally, Your Honors, I go back to the case of Gio Samar, which we decided in 2019. There, the court affirmed the decision of the hierarchy of courts as a solution to the problem of clogged court dockets. We said strict observance of the doctrine of the hierarchy of courts is a constitutional imperative, not a quote matter of mere policy. Your Honors, Gio Samar cited the Judiciary Annual Report of 2016, which indicated a total caseload of 14,491 cases as of December 2016. In 2017, this number dipped to 14,411, rose to 15,000 in 2018, before dropping to 14,000 at the end of 2019. Notably, despite Gio Samar and the relentless efforts of three Chief Justices, namely Teresita L. de Castro, Lucas P. Bersamin, and Diosdado M. Peralta, to introduce reforms, the docket of cases pending with the court at the close of 2019 remains at nearly the same level as it was in 2016. To end, I would like to join the call made last March 29 by 22 organizations representing the business community. 3 law school deans in Iloilo City, and the Iloilo Integrated Bar. They must urgently petition this court to declare once and for all that the 24-month period mandated by the Constitution to decide a case is mandatory, and that it should be dutifully observed by this honorable court. Be reminded that justice delayed is justice denied. Your Honors, we hope that the court takes due heed and notice of this appeal. Thank you.
Thank you, former Justice Francis Adelessa. Also, the court earlier received a letter from Congressman Edsel Lagban, who would wish to address the court by way of manifestation. Congressman Lagban, we're giving you 10 minutes for your manifestation.
May it please the Honorable Court. Your Honors, I was intending to make a manifestation regarding the status of our omnibus motion which we filed last Friday afternoon. Considering the statements of the Honorable Chief Justice that the omnibus motion will have to be resolved after the respondents are given time to respond. And also that the recall of the National Security Advisor respondent, Jared Esperon, will not be continued today, considering the pendency of our unresolved urgent omnibus motion. Then I think that there is no more need for me to elaborate on this pending motion, which we filed last Friday. Thank you, Your Honor.
Thank you, Congressman Lagban. So the court would like to reiterate its earlier resolution for purposes of concluding the arguments, oral arguments in this case. So the parties are required to submit their memorandum on the basis of the clustering agreed upon by the petitioner's counsel as stated in their manifestation. So the clustering will be based on the issues that they agreed to present during the oral argument. The court will issue a resolution setting forth the contents of the parties' memorandum, particularly as regards respondents' memorandum, because the court will issue a resolution that contains other matters that the court wants to be clarified on certain issues intended for Secretary Esperon to amplify. The court will issue that resolution by email, and the counting of the period, which is 30 days, non-extendable, for party submission of the memorandum will be based. So, there being no other matters for purposes of this oral argument, the court concludes the oral argument in these petitions. Adjourn the session.
Please remain in your respective seats while the Chief Justice and the Associate Justices leave the virtual session hall.